Defendant was convicted of harassment in the second degree after a non-jury trial. On appeal, he contends that the charge should have been dismissed on statutory grounds. We disagree. An information signed by a police officer was filed in Buffalo City Court on June 5, 1998, charging defendant with criminal contempt in the second degree, a Class A misdemeanor, harassment in the second degree, a violation. The information referenced a supporting deposition signed by defendant's estranged wife, who alleged that on May 19, 1998, in violation of a family court order of protection, defendant drove by her home on several occasions and shouted obscenities. In a subsequent deposition, she detailed that the defendant had yelled at her that she was going to be dead and would be leaving Buffalo in a body bag. He also telephoned her and stated he would set fire to her house if her boyfriend visited her home. Buffalo City Court issued a summons directing defendant to appear. Defendant went to police headquarters on July 14, 1998 to pick up the summons, and that same day he was assigned counsel and arraigned. He entered a plea of not guilty and a pretrial conference was scheduled. The Erie County District Attorney's Office was first advised of the charges against defendant on the day of arraignment. At the August 7th pretrial conference, defendant's attorney indicated that he intended to serve discovery motions on the district attorney's office, and the people announced their readiness for trial. The matter was adjourned to September 8th, and on that date, the parties agreed that discovery was complex and not completed, and a trial date was set on October 28th. The scheduled trial date, the people appeared with their witness, but the trial was postponed to December 21st when it was determined that one of the witnesses could not testify without the aid of an interpreter for the hearing impaired. On the adjourned trial date, defendant moved to dismiss the information on statutory speedy trial grounds, contending that the appropriate time frame was 90 days after the filing of the statutory instrument, and the people had failed to timely proceed because they were chargeable with two significant periods of delay: the 39 days between the filing of the information and arraignment, and an additional 55 days of postponement. Defendant further claimed that the prosecutor's statement of readiness was illusory because a copy of the order of protection underlying the criminal contempt charge had never been filed. The people agreed that the appropriate time period was 90 days, but argued they were chargeable with only 24 of the 199 days between the filing of the information and the December 21st trial date, the period between the arraignment on July 14th and the statement of readiness on August 7th. They asserted that the pre-arraignment period was excludable as an exceptional circumstance because the people did not know charges were pending against defendant until the date defendant was arraigned. Finally, the people contended their statement of readiness was valid because they had procured a certified copy of the order of protection, and the police had confirmed the order's existence before filing charges. Although the parties concurred that the applicable speedy trial period was 90 days from the filing of the accusatory instrument, City Court employed a different analysis, concluding that the allegations underlying the criminal contempt charge were insufficient. The court dismissed the misdemeanor charge and reasoned that because the remaining harassment charge was a violation, the people were required to announce readiness for trial within 90 days under CPLR. Nonetheless, City Court held that the action was time barred because the 39-day arraignment period was excludable due to the people's lack of knowledge of the charge, and the people had announced readiness within 24 days after the arraignment, thereby meeting the 30-day time requirement. Defendant's claim of post-readiness delay was also rejected. That was pretty snappy.